Welcome to Oil and Gas. Today we are going to talk about how pooling affects some other property rights like non-participating, royalty interests, etc. So as a basic, here's some of the basic ways that it can affect your property rights through pooling. So one question is, what happens to your lease? So we know that if there is production on any part of the pooled unit, that's treated as production on all the leases within the unit. So, in your pooling clause, usually it will say that the production, even if it's not taking place on the land, if it's attributed to your acreage through a pooled unit, that's going to be sufficient to hold the lease. It will hold all of it unless you have a retained acreage or pew clause, but at the minimum, it will hold some of it. We also want to think about how does it affect that lessor's interest. The lessor has a background interest in his or her land, a reversionary interest that reverts to him or her once that lease ends. But how is that affected by pooling? We'll see that in one common theory is that effectively there's been a cross conveyance of interest between those neighboring landowners who pooled their land together for a unit. We'll also talk about the effect of pooling on a non-participating royalty interest holder. So the lease that the lessor signs allows the oil and gas company to pool his or her land, but the non-participating royalty interest holder usually will not have given any authority to pool his or her interest in the land. So how does a lease affect that owner? Then, of course, we have to talk about the effect on term interest, those terminable interest, which is some kind of mineral interest that potentially only lasts for a while or potentially can last longer if there's oil and gas production. So let's start with this Wagner and Brown versus Shepard case. In this case, the plaintiffs had a 1/8 mineral interest. Okay, so instead of having a half mineral interest or a quarter, they have a 1/8 mineral interest. And that was pooled under a lease. So they had signed a lease, then their land was pooled, but the lease terminated, in this case, because royalties were not paid in a timely fashion, and that lease, unusually, made the lease continuation dependent on timely payment of royalties. Royalties were not paid in a timely fashion, the lease terminates, but the other leases that are in this pooled unit continued. And so the question here was, in this case, there are actual wells on the land that the plaintiffs had a 1/8 mineral interest in. Now, should they get 1/8 of all the production, all the profit out of the wells on their land? Or do they only get 1/8 of their share of the pooled unit? That is, do they remain within the pooled unit because they were pooled under a lease, but that pooled unit, that lease terminated, so that lease is no longer valid? Well, for the court here, it says the question comes down to what the lease's pooling clause says. And the lease's pooling clause says that it gives the oil and gas company the power to pool the premises or lands rather than just the leased interest. So when the oil and gas company pooled that land into a unit, it basically affected a cross conveyance of interest where the plaintiffs now shared in the production from that entire pooled unit. So even when the lease goes away, the pooling continues. So the court is saying, effectively, we're going to look at the lease instrument to figure out what can be pooled. And I'll show you some example lease language in a second, similar to what was used here, that pooling authority is governed by what the parties said in the pooling clause. That says they bind the whole land. And so even when the land reverts to the plaintiff because the lease ends, that means that the two wells that are on plaintiff's land are still part of that pooled unit. So the plaintiff still has to share the production with them. The lease could have specified a different rule. So the lease could have said that the oil and gas company lessee only had the power to pool the leasehold interest, but instead it gave power to pool the premises and lands. As a result, the plaintiff is now unleased, so they are going to get what an unleased co-tenant gets in this pooled unit. So you take the pooled unit, say what's their share, right? They would like to claim all of it because the wells are actually on their land, but they're part of the pooled unit, so they only get their share. Then within their share, they get an accounting. So after the costs are paid back for drilling, they get all the profit. So they're like an unleased co-tenant. That's a pretty good situation to be in. Yes, you have to wait until the well is paid off before you start recovering your share of the profit, but you're probably, from a good well, you're going to end up with more money overall. And also, if there are dry wells, so if there are wells where the oil and gas company drills and doesn't get anything, you don't have to pay anything. So, so they're basically an unleased co-tenant, but they still participate in this pool unit. All right. So this case had a very kind of standard Texas pooling clause. Here's another example. You only need to focus on the bolded part here. The lessee is hereby given the right and power to pool or combine the acreage covered by this lease with other land, lease, or leases in the immediate vicinity. Okay, if you were looking at this at the court, what would tell you whether this gives you the power to pool just the leasehold interest or the underlying land? Okay, so this allows pooling the acreage, right? It doesn't say just pooling the lease or the leasehold interest. It allows pooling of acreage with land. That means you're allowed to pool that underlying interest. All right, let's talk about London versus Merriman. And this is a great example of how difficult it can get if you have a non-participating royalty interest on your land and you want to pool it. So basically, London had two tracts and leased them together. So London leases them with a standard pooling clause. Okay. The problem was that Merriman had a 1/16 non-participating royalty interest in the west tract. So there's two tracts, and Merriman has a 1/16 non-participating royalty interest in that west one. Now, London, as the landowner, of course, has the power to say, go ahead and pool my land if you want to. But London has to exclude Merriman from that, because Merriman didn't, when he took that 1/16 non-participating royalty interest, he didn't say, hey, go ahead and pool me into that neighboring land if you want to. So London is like a little bit sensitive to that, and so says, well, look, I'm not necessarily pooling. Says, there's no pooling just automatically because I lease these two tracts together. So no pooling of royalty merely from inclusion of the separate tracts. The problem is that it gives the oil and gas company the authority to pool those at any time. And what's the worry here? Well, remember, the courts can be a little bit skeptical of pooling, and they're worried about pooling being used to harm Merriman, because the thought is, well, look, if there's production on Merriman's land and they want to minimize that, well, won't they just pool it with the neighboring tract and say, hey, you only get half of it. So you were supposed to be getting 1/16 from this well on the west side, but it's going to be 1/32 because we pooled it with this neighboring land. So that's what the courts are concerned about. What happened actually here is that there's drilling on the east tract. So there is drilling over here. Okay, it produces oil. And Merriman says, well, wait a second, you put me in this situation where you could have pooled to harm me if production was on the west track. So if it's on the east track, you got to let me get my share of that as well, because you put me in the situation where I could be pooled with this east track and I want that share of royalty. The court says that's what should happen here. By granting the lease with an unauthorized pooling clause that allowed you to pool in Merriman's land, that basically was an offer to the royalty owners to ratify and allow pooling. Okay, so what we'll see is that either if you have a non-participating royalty interest or a co-tenant, you have to be really clear that you are not allowing a lease or pooling of their interest. So as an example, we'll talk about co-tenant ratification. So obviously, as we discussed last time, a co-tenant can lease their undivided interest by themselves. So even if a co-tenant just owns an undivided 50% interest, the co-tenant can lease that undivided 50% interest and can allow the oil and gas company to go on and start producing. Okay, but what sometimes happens is somebody's really just a co-tenant, but they grant a lease of all the minerals. So they say, you know what, oil and gas company, go ahead and, I'm leasing you 100% of the minerals, and don't mention, wait a second, somebody owns the other 50%. In that circumstance, the unleased co-tenant, the co-tenant who was wrongly sort of stepped over and somebody leased on their behalf, can either ratify the lease and then they will get all the lease benefits for their share. So basically after the fact, they can say, yeah, that lease you signed, that's fine, go ahead. I want my mineral interest, my 50% mineral interest leased on the same terms. Okay, so then they just get bonus and royalty like the other co-tenant. Or they can refuse to ratify the lease and collect what they should as an unleased co-tenant, which is basically an accounting. So their share of the profits for their share of the mineral interest. Now that's obviously best in the usual situation where you have a very profitable well. On the other hand, if there was a completely dry well, well then maybe you want to ratify the lease because at least you'll get a bonus. And if the well is only barely profitable, there's going to be very little after the well itself is paid for, well, then you might want that little bit of royalty anyway, because the advantage of a royalty, yes, you get less overall from a great well, but you at least get a share of production as soon as production starts. So that co-tenant has the choice if somebody wrongly leased on their behalf. Okay, so that is a sort of standing principle in oil and gas law. What we'll see is that it's a similar sort of principle that's at play in London versus Merriman, which we just discussed, which is what happens if you purport to allow pooling of a piece of land that really has an outstanding non-participating royalty interest owner on it. Okay, you can lease that land, but you can't pool the rights of a non-participating royalty interest holder unless they said you could. So if you lease with a pooling clause and don't say anything about this non-participating royalty interest holder, then again, just like we saw in London versus Merriman, the non-participating royalty owner can either ratify the pooling and say, you know what, yeah, I want you to pool because the production is happening as it did in London versus Merriman, not on my track. So I'd like to be pooled with them, so at least I get a share of that production. Or you can say, no, you can't pool me. Give me the full royalty in my tract. And you would want to do that, obviously, if the production is just on your land. So like, in the example of London versus Merriman, if it had been just on the west tract. Okay, so basically, moral of the story is you want to be clear about what pooling you're allowing in the lease. If you have a co-tenant, don't lease their share, right? Similarly, if you have a non-participating royalty interest holder, when you lease, be clear that you can't, that part of the interest cannot be pooled, and ideally get them to ratify it. So if you want to allow pooling, then you can get that non-participating royalty interest holder to sign off on it. Now, why would they sign off on it when they could just wait and see what happens and get more money potentially? Well, one reason they might sign off on it is because an oil and gas company might not be willing to drill unless they have the power to pool that land, because there's so many circumstances where pooling might be necessary to get efficient production. And so obviously, as a non-participating royalty interest holder, the only way you benefit from that is if there is production on the land. So you might be willing to ratify the lease as long as you're told beforehand. But what you don't want to do is lease your land with a pooling clause without any mention of a non-participating royalty interest holder, because then they're going to be able to sort of come back after the fact, as they did in London versus Merriman, and just choose whatever choice gets them the most oil from your share. Okay, last big issue. Let's talk about terminable interest and pooling, or in this case, unitization. This is a Kansas case. What happened here is that the defendant had a defeasible mineral interest, defeasible term mineral interest. So it lasts a certain number of years, plus as long as oil and gas is produced. You remember we talked about these term interests earlier in the course. Okay, this terminable interest applied to the north half and southeast quarter of section 31. You can see it on page 679 in your text. It's like the the little shaded portion on the left of that map. And basically what happened here was that the southeast quarter of that land was force unitized with other lands. It was later plugged. And so you'd say, okay, well then that mineral interest is over because it only continued so long as oil and gas is produced. But the issue is there was production that continued in the unit. What the court here says is, and this is the Kansas rule, that, okay, that actually kept that mineral interest going, but only for the portion that is within the unit. So only for that southeast quarter, which you can see on the map, not for that north 1/2. And I think one question you could think about, is that when we talked about that other terminable interest case, Archer County versus Webb, one of the questions we had that was about was, will shut-in royalties maintain a lease? Is shut-in royalties production? Is oil and gas being produced if shut-in royalties are being paid? There, we found the answer was no. Both in Texas and Oklahoma, shut-in royalties not enough to maintain the lease. So, the question is, well, so why should unitization, if that is enough? Is it because, unlike a shut-in royalty, some oil and gas is being produced somewhere at least, so even though it's not being produced on the southeast quarter, it's actually being produced elsewhere in the unit. That's enough because it's being attributed to the southeast quarter. And you can see another big issue in that case is, well, why should you split up this land? Shouldn't, if there's any production attributed to any part of the land, shouldn't you be able to keep the north 1/2 as well? All right.